Good morning, everyone. This is Russell Rucker, and I'm here for another constitutional talk. And with the arguments this week in the Supreme Court, I feel compelled to go back again to the 14th and discuss it a little bit. And the 14th Amendment, Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. All persons naturalized in the United States, born or naturalized, and that's key, is subject of the jurisdiction thereof. Now, this whole, and I'm reading from textualism and originalism in our constitutional republic. I want to get back to the genesis of this amendment, and that is the Dred Scott decision. Dred Scott was a slave. He was brought up into Wisconsin, I believe, into a free state. And he argued in court that he was now free because it was illegal in the state he was now in to be a slave because it was a free state. The court ruled that he had no right to sue, basically claiming he was property and property had no standing in a court to sue. So they pretty much threw the case out is really what happened. And there was a lot of outrage up north because of this case. And then you have the Great Civil War happens. So the South is decimated. Slavery is eradicated. And they write up the 14th and really the 13th through the 15th to deal with slavery and the end results of it. And the 14th has to do with making citizens out of children of the former slaves. They felt that they were owed that much. Kind of a reparation, as they would like to call it today, to give the blacks equality and give them a chance in the courts and make them full citizens. And all these amendments do get to the point of doing that. Fast forward another 20 years and we have Wong Kim Ark. Now, Wong Kim Ark came here from China. His parents came here from China. And he was born here. Every intention was to be a citizen. He assimilated. He became into the culture. His parents wound up going back, and they tried to deport him. And he sued, claiming that he was a citizen. And the court ruled that he was a citizen by virtue of his birth here. But the key difference between, and people keep pointing to this case, but the big difference here is he was not an illegal immigrant. His parents weren't illegal. He didn't illegally cross the border. He came here in a legal manner and even tried to assimilate into our culture. So they want to bring this up, and this jurisdiction thereof has a lot of meaning, because originally they tried to pass the amendment without that and the jurisdiction thereof, and it died. And it died because they didn't want to just give everybody citizenship that happened to stroll into the country. And people want to point, well, they have to obey the laws here. So they are subject to the jurisdiction. Well, not really. Because in order to be a subject, you have to have no other foreign allegiances. And that's where we get to with some of these cases. Now, we move forward another period of time and we get to the Elk case. Elk was an American Indian who left the reservation and lived among the whites, and he sued for his citizenship, claiming he was born here. And he was denied because he was an Indian, and therefore he had no right to citizenship, even though he was born in the country, to parents who were born in the country, and their parents parents were born in the country. And if the subject to the jurisdiction thereof really meant what some try to argue, that if they were born here regardless and they were subject to our laws and all this, then we wouldn't have had to go through and make Indian citizenship in a 1924 Indian Citizenship Act. And you can argue, because Elk lived on the reservation, that he was not subject to our jurisdiction because they had their own laws. But he had left the reservation, and he was living among the whites. If he had done a crime, he certainly would have been found guilty and prosecuted for that crime. So this whole idea that subject to jurisdiction thereof means that they only have to be here. That's a real elementary way of looking at it. It's not getting to the heart of the matter. Now, as our Supreme Court grapples with the problems of this amendment, and I'm not saying that they're going to agree with me and rule the way I say. In fact, I think they'll rule the exact opposite, because I think politics will get into the court and they'll rule what they think the people want, rather than ruling what the amendment actually says. Our Supreme Court doesn't always get everything right, but that doesn't mean that they're correct. Many times we have opinions overturned time and time again, until finally you get to a settled law where it makes sense. Did Dred Scott, did he have a right to sue for his citizenship? I think he did. Did a slave have standing? I think he did. He lived within the continental United States. By no virtue of his own, his master had taken him into a free state. There are lots of court rulings that have been overturned. There are lots of times the Supreme Court has not always got it correct. And maybe they will this time. I don't know. But it's important to take a look at what the Constitution actually says. Not how somebody tries to warp it and give an incorrect interpretation of it. That's why I don't normally look at Supreme Court cases and decisions. Here I have, because I'm trying to point out the incorrect interpretation that's out there of this amendment. So I'm going back to show you what things can actually happen. I hope you get something from this talk that helps you better understand what the amendment actually is supposed to mean, what it actually does say. And with that, we'll catch you next time on the next Constitutional Talk. Have a good day, folks. We'll see you next week, next time on the next Constitutional Talk. Goodbye for now.